And just before we recommence, there may be an interruption at around about 3:15 with a matter to do with this building. I'll be furiously looking through the contempt powers if it occurs. Mr. Evans, we've had a request for Mr. Sargent's statement from the media. We intend to there's no documents attached, so it's just a statement. But as a matter of courtesy, we're letting you know.
Yes, and I've actually, with Mr. Federal's consent, I've consulted Mr. Sargent. We have no issue with that.
Right. Thank you. And while you're on your feet, Mr. Evans, that question I asked about the prescriptions under section 29, capital A, at some stage, could you just tell us what was the method by which the prescription was made? Because there don't seem to be any regulations.
My understanding is done by gazettal notice rather than regulation, but it should be discoverable in the Gazette. I'll have some inquiries made.
Right, thank you. Mr. Federal.
May it please the Commission. Commissioners, I think I omitted to tender the two documents, or the Annexure A and Annexure B, which I have, which took Mr. Sargent prior to lunch. So I would formally tender that document, or those documents. It could probably go under one item.
We think separately numbered.
Those documents might already have been tendered yesterday.
I don't believe they were.
Well, I don't have a...
Perhaps we can sort this out later, but I understand that the response of the 15th of April is in. It was tendered yesterday, but the 22nd April was not tendered yesterday, which is, I haven't tendered the letter, I only wish to tender the annexures.
Annexures, yeah. The document QNE.0001.0001.0001, which is Annexure A, will be admitted into evidence as an exhibit if it hasn't already been admitted. The document QNE.0001.0001.0014, which is Annexure B, will be admitted into evidence as an exhibit. Thank you.
Right, Mr. Sargent, in your statement, you have said that the GWC did not have a specific budgeting philosophy for resourcing the regulation and oversight of the Perth casino. And you've also said a pool of funds was allocated by the department in accordance with the budget set by the department and approved by the GWC to undertake the GWC's activities. I'm referring you to paragraph 63 of your statement, if you have that in front of you. Are you familiar, or do you remain familiar with the provisions of the Financial Management Act?
Not at present, no, but you remind me.
I just, the process you described, if you could just look at paragraphs 63, 64 and 65, are you describing the budgeting process there in substance as the means by which the GWC complied with its obligations under that Act? So you understand the GWC was obliged to prepare an annual estimate? And so when you say the department prepared the budget, it was prepared by the Chief Financial Officer of the department, wasn't it?
For submission to the GWC.
Yes. And so the person who was the CFO of the department fulfilled the same function as CFO of the GWC?
Correct.
And I think while you've expressed this statement in the past tense, as in what the position used to be, that remains the case today based on your experiences?
I would say, I'd confirm that, yes.
Could I, just by way of an example of this, just take you through the process we've described? I have some questions to ask you about the budgeting process itself, to see if it's any differences between what happened in the past and what's currently happening. And if I could ask that we produce, or the document GWC .002, .0016, .0228 at page 1 be called up. It appears to have been redacted. This is should be a minute, an agenda of a meeting on the 27th of March 2018, and just to draw your attention to the following, the second page, page 2, under the heading 11 Commission Matters, and then there's a reference there to the GWC budget. And then a little further on in the document to page 212, there is an item for that agenda item 11.3. Now the author is, do you know how to pronounce that name?
No, I can't.
That person occupied the position of Chief Financial Officer of the department at the time.
Was that a question? Sorry.
Yes, sorry. Her name is Shanaeya. I'll spell it Shanaeya. Sherdiwala. Sherdiwala. She was the Director and Portfolio Chief Financial Officer for the department in March 2018.
I'll have to accept that
You don't know?
I don't really know.
That's
No,
fine.
I can't recall that. No.
Okay. Now, I'll just draw your attention to begin with, do you have any recollection of attending the meeting on the 28th of March 2018?
I would suspect so, but I can't be specific. The minute should reflect whether I did or I didn't.
Yes.
I would expect I did.
Can I just ask you some general questions about the process then, at least? So
Yeah.
if I draw your attention to the page 213, and there's a heading recoup to DLGSC, an amount of 4,140,575, and there's an explanation about briefly to support the commission. And the next heading is a casino gaming licence fee. It identifies that as 2,929,286.
Yes.
And then if you move into the memorandum proper, there's a memorandum from Mr. Ord. To Mr. Ord as Director General. From someone describing themselves as the Chief Financial Officer of the 14th of March 2018. And if I could just draw your attention to page 217. And there's a reference under cost of services to services provided by DLGSC. Now this is a budget.
Mm-hmm.
Now those are the services that your evidence was deal with a little earlier today, of the administrative and the regulatory nature provided by the department to the GWC, correct?
Yes.
And the revenues from services, which is under the next heading a little further down, identifies fees that the GWC obtains from the casino licensing, and they're identified there again as a budgetary item. To your knowledge, is there, in what manner, and this is, I'm speaking now about when you were Director General of the department and Chair of the GWC, in what manner were the amounts identified in the budgets, annual budgets for the services provided by the DLGSC determined?
The main structure was to look at the number of people in the area and what was being supported, and over time, I think it would have been set probably many years ago. It just got an adjustment, either if the numbers were down or if the costs gone up because of salary rises, etc. But there was no process whereby you went down and individually identified exactly what people were doing. There was no contract in that.
So is it the case that it was a direct recovery of the cost of the employment costs of those individuals?
There would have been some overheads because we had rent and things to pay as well. So it wasn't just that the department had overheads to cover. So you had the direct costs, but the department has more than just salaries to meet.
So there was a charge for the salary cost of the employees in question, plus some overhead component.
That's correct. That's my recollection of it.
And who determined the overhead component and the recovery of that?
That was money left up to the finance people to work through.
And was the breakdown provided to the GWC of the way in which that was calculated?
Not that I recall, no.
And who determined, so I think, who determined or if you like, which employee costs would be included in the budget item for the services provided by the department?
Well, that I would have just left to the management of the particular division. So in the latter divisions, that was coming through from the Deputy Director General area, because we had licensing people as well as regulation under those. So there was some breakups in the sections, and that wasn't something that I addressed personally, and it wasn't something that the Commission addressed.
So coming back to some of the earlier evidence today, then the department, and again, you can feel free to disagree with this.
Yeah.
I'm just trying to summarise it. The department identified and determined the number of government officers or inspectors who would be required to fulfil the functions of the GWC. It employed them. It prepared a budget for the cost recovery of the provision of their services to the GWC, and then presented essentially that budget to the GWC at a meeting annually.
Annually. The only qualification I can put on that is that there would have had to been some allocation of people to their liquor duties, because, as I said before, the inspectors covered the gaming, which included casino and community, and wagering, and it also did some liquor. So there should have been some recognitions in that process for the fact that a percentage of the regulator's time, the inspector's time, would have been devoted to liquor licensing.
So there would have been some, you think there was some form of apportionment of the costs between liquor and gaming?
I expect so, yes.
And when you say you expect so, do you know so?
No, I don't know so. I can't confirm that.
And so then, to your knowledge, was the breakdown of that ever provided to the members of the GWC for verification?
I would say no.
So at the time then that the budget was annually delivered to the members of the GWC, was there any discussion around the budgetary items, to your recollection?
I can't recall detailed discussion. Yeah.
Is it fair to say then it was essentially approved without really any question?
I'd say that would be a fair comment, yeah.
And that was during the period that you were chair of the GWC?
That would be the case, yes.
And has that remained the case on your observations?
In my opinion, yes.
Since you've been a member?
Yes, in my opinion, yes.
Okay, now, in your statement, you've also given evidence that you were unaware of the GWC having any specific policies in place regarding the regulation and oversight of the Perth casino or the risk associated with junket operations, money laundering, cash and electronic transactions at the Perth casino and criminals infiltrating casino operations, which you have described or defined in your statement as risks. So when I'm referring now to risks, that's what I'm referring to, and that's at paragraph 19 of your statement. You've also said that, I'm now drawing your attention to paragraph 75 of your statement, that the GWC does not have many policies and procedures relating to the exercise of its powers and discharge of its responsibilities and obligations in respect to the regulation and oversight of the Perth casino generally, and the risks, that's those risks, specifically. And if I could just draw your attention to paragraph 75 of your statement, because I have some questions. Now, you have provided an explanation for the absence of any or many policies, and you identify a number of reasons. One is that the Perth casino is operated in accordance with a casino manual, which is very detailed in its procedures and processes. What is your understanding of the manner in which that casino manual addresses the risks, as I say, those risks that you've defined in your description of risks?
That manual addressed the risks within the casino footprint, because that's where the audit was. So it was about compliance with procedures, compliance with the rules, and the procedures included accounting for the money, table supervisions, and movement of chips and things along those lines.
I understand it, but what I'm specifically asking you about is your understanding of how that manual addressed specifically money laundering, criminals infiltrating casino operations and matters of that nature.
In the other parts of my evidence, I did make comment about whether the Gaming Wagering Commission is basically the appropriate body to look at money, the address with money laundering broadly, and if you look at the powers that particularly the Commonwealth bodies have, they're empowered statutorily to look at money laundering. They've resourced, they're trained to identify, investigate, and deal with money laundering. So my view was that in case of that risk for the casino, it was something that was covered by another body. It wasn't one that we had the resources for. But that doesn't mean to say that we don't have concern for the money if it was found within the context of the casino footprint.
So, do I understand from that if you like, the real reason, as I say, it wasn't, you're not suggesting, are you, that the operations manual actually did cover and deal with those risks, to your knowledge?
No, I'm not. If I hadn't applied that, that's not correct.
Okay, so the reason you've given for effectively not addressing the risk specifically is because of the evidence you've given elsewhere about it being matters within within the remit of other government authorities as to investigate criminal activity, including at the casino?
Well, we weren't a law enforcement agency in that regard. Now, we do have specific powers to investigate matters. You know, if you look at the powers under Section 19, then if we identify something, we do have those powers to investigate. But it's still a matter of us then reporting to the Minister on the outcome of those investigations. So, if we're involved in anything to do with criminality, we rely very much on the WA Police for those matters. And as I said, with respect to the money laundering in the broader sense, outside the footprint of the casino, we're relying on particularly the ice-track.
So when you're saying we in that, are you identifying the we with the members of the GWC or the department or both?
I'd say both.
Both. So in paragraph 26.1 of your statement, you have said that you going back to support, this is a support matter, provided by the department to the GWC is adequate, and you say, for example, the department takes the lead on policy formulation and development, and then provides that policy to the GWC for consideration and approval. In what you just described about the, if you like, leaving, call it the capital R risks to other government agencies to investigate, prosecute, etc. Is that a policy that was developed by the department and provided essentially for endorsement by the GWC, or was it developed in some other way?
If I can put it into the context, I think it was a policy that perhaps is not in the same terms of the agencies available. But when I joined the department and the commission, ice-track was in place then, and I can't say it was something developed separately, but it was something I inherited and just continued along those lines. So it wasn't. I can't recall going back to the commission and preparing a paper to specifically change that position.
Well, then, what was the position before Austrac then? What was the position of the commission, or sorry, the GWC, and or the department before the introduction of that legislation by the Commonwealth?
I don't know. It was something which that legislation came to being about 1989, and I joined in 92. But I can't go back to give any reference to a specific position then. No.
Okay, so just dealing with that topic then, this is the Austrac subject matter. This is dealt with in paragraphs essentially 79 and 80 of your statement, and leave to one side 79, which is the deal with junkets. You're really discussing at the moment with me what you've said in paragraph 80, correct?
Yep, it's about, yeah.
And
it's about, yep.
And you've said there that you again talking about these risks, there's let's call them the criminal risks, the criminal infiltration risks. You said, I don't believe that this was or should be a responsibility of the GWC. So we've been dealing with the aspect of it. You don't believe it was. Why do you say you don't believe it should be a responsibility of the GWC?
Well, I don't think we're in a position to provide the sophisticated financial analysis tools would be required for that. If you look at the expertise now in probably criminals trying to launder money, an organisation such as Austrac is far better resourced than I think the Gaming and Wagering Commission would be. And whenever we've, particularly when I've gone to conferences and they've talked about the involvement of Austrac, there always comes the issue of state versus Commonwealth legislation too. You know, one of the aspects of the Austrac legislation, and this I think was an issue for the Commission, is that once they've lodged a document with Austrac, then the secret provisions, I understand, are invoked. which means it's very hard to get information on those aspects. But I was of the view, and now I'm more expressing it from here on more than anything else. I still am of the view that it would be far better to have a well-resourced agency to do it than to disparate over a number of agencies.
When you say a well-resourced agency, are you drawing a distinction there between the GWC and a Commonwealth agency, or are you suggesting that it would be better to have a well-resourced state agency with responsibility for investigating risks of this nature at the casino?
I think a Commonwealth body, because our legislation is restricted to Western Australia, and particularly now with the way that the casinos operate in the international market, monies are coming in overseas and come in from the other parts of Australia. So it's not so easy, in my opinion, for a state-based organisation to go to the extent to which a Commonwealth-based organisation would.
Okay, now I think at this point I think your evidence is really addressing to the question of a detection and prosecution of criminal behaviour. Would that be fair?
In detection in what in Western Australia
in the casino environment of matters such as money laundering or other forms of infiltration of criminal elements.
If it was evident within the footprint, so to speak, then we would have a responsibility if it was evident.
If it was evident, so that's a question of whether if you become aware of something in the course of the exercise of the functions of the GWC, you then are aware of it and you need to do something about it.
You would, and in the first instance, we would probably be involved in West Australian Police.
The question is whether you would go looking, so to be proactive about
looking to the extent of what's happening on the floor is one thing, but if we were to go looking and invoking the powers which are available under the Casino Control Act and the Game Wagering Commission to investigate, we would have been looking for some sort of evidence that something was wrong.
So, sorry, in that answer, are you accepting then, are you, that there is power, or there would be power of the GWC under the current legislative framework to carry out a proactive investigation of risks such as money laundering or other forms of criminal infiltration?
We could do within Western Australia.
And do I understand your evidence then to be the reason that you have effectively not undertaken that proactive task is because you don't have the skill set within the GWC to do so?
Well, that's one aspect of it, but I also consider that because it goes beyond West Australian borders, I'm not sure how effective our investigation would be. If we were, from my perspective, I would have relied on someone like the Commissioner of Police or one of his delegates or someone to raise an issue with us rather than us being able to devote resources to finding something. That doesn't mean to say that we're not conscious of it within the footprint of the casino.
But there is a power, isn't there, for you to seek advice from the Commissioner of Police under the Gaming and Wagering Act?
I can't recall. I'll have to accept that. I think there.
If you can't recall, it's...
No, I just can't recall that's under the Game and Wagering West Australia Act, yeah.
And I think earlier today you accepted there's a power of the GWC and all the department for that matter to employ experts, consultants as required to fill any gaps there may be in the skill set of the department. So it's certainly possible, is it not, to utilise the services of people expert in forensic analysis and that sort of thing outside of the department?
It's possible, but as I said before, we'd be looking for something evidentiary to justify going down that path.
I see. So is it a question of resources then? Funding?
I don't think so. It's a matter of the priority in which we would operate. No, the resources, whilst they're limited, I don't think it would have been a stopgap exercise to not to go forward.
Can I ask you some questions about the, I mean, you mentioned AUSTRAC and it's obviously a Commonwealth authority that gathers information effectively and passes information on to other agencies.
Sorry, I don't think they'd pass it on to us because we're not a law enforcement agency under their legislation, so they'd be limited to where they would pass it on to.
That was what I was going to ask you about. So are you aware of any memorandum of understanding or anything of that nature with AUSTRAC or other agencies that would allow them to pass on information that would assist you to regulate the casino?
The only memorandum was with other, like the Victorian regulator, those sort of agencies. We had a memorandum of understanding for exchange of information. We didn't have a memorandum with the West Australian Police. The department over the years has had a very good working relationship with the police. So there was no formal memorandum.
So the Western Australian Police Force, presumably, would be a relevant source of information about criminal activity in the state generally. Would you agree with that?
Oh, yes.
And it presumably would have intelligence relating to any criminal activity in the casino in particular. So it is a source. The West Australian Police Force is a source of information that could have been utilised by the GWC. Would you agree with that?
When you say could have utilised, if I was probably putting it the other way, I was relying more on the police to raise matters with us rather than us going the other way.
Right. So, just in a general sense, would it be fair to say that the position of the GWC, as you understand it, was to leave any investigation of criminal activity to agencies specifically tasked with that responsibility?
Yes.
And rely on them to raise with you any concerning behaviour there may have been at the Perth casino?
Or whether we would use our powers to investigate something which may not be directly related to the casino at that point, but it could have some impact on the casino.
Aside from the investigation of actual criminal activity that's taking place, as I say, something that's historically happened, would you agree with me that there is, because of the nature of the activities involved in the casino, there's a risk it will attract criminal elements to the establishment?
It could do, but the issue is there's no way that we would know who they are unless the police would provide that information to us.
I accept that you wouldn't necessarily know who they were, but it would be something such as money laundering, for example, is an activity that might be undertaken or a casino may be used for that purpose.
But part of the answer to that depends on how they are doing it. If they were to come to the casino to try and money launder, for instance, one of the rules in the manual was respect to what they call winning checks. That if someone was to front up to the cage with a stack of chips and want a check, then the cage procedures required them to check that they had actually gambled the money. So there was something internally. The issue was when if there was money laundering being used, like has come to light with respect to the Riverbank account. That's not so easy for us to detect.
At the moment, I'm just speaking in generalities rather than specifics because I'm asking questions about whether the risk of there being infiltration, if you like, had been identified, and if so, what the GWC had done to satisfy itself that the licensee was managing those risks adequately.
What would you class as infiltration? What sort of example would you think that would be?
Well, by way of example, the use of organised crime connected with junket operations as an example, where that's one example that springs to mind.
Well, the issue with junket operations is that we rely totally on the police to assess the credibility of those organisations, and that's we'll probably ask questions about it later on in respect to the change in the regulations. But it's a matter which would have to come from the police as to whether someone was suitable or not. And there was no evidence that the police had any concerns with the junket operators.
Really, what I'm asking you is, did the GWC identify the possibility of let's call it association of criminals with gambling activities as a risk that required management by the licensee?
Yeah, I can understand that, yes.
And it was identified as something that required management by the licensee?
That it was identified, but whether it was specifically set out in I don't think it was set out in the specific policy. But the issue is that whenever I was to deal with the licensee over any matters to do with money laundering, we were given the assurances that they are complying with AUSTRAC requirements, and that's spelled out currently the things about know your client, etc.
So you were satisfied that the risk has been adequately managed because of the requirement to meet the AUSTRAC
Yes.
reporting obligations?
That was my assessment, yes.
You have foreseen that I want to take you to the junket issue as well, to understand a little bit more about that. Now, you've mentioned in your statement, I think you just mentioned again now, that there was a change in the regulations relating to the way in which junkets were regulated by the GWC. Just what is your understanding of a junket?
Well, it's basically a person that organises a group of people to come to the casino, and in return for that service, they will get a commission on the activity that particular group provides to the casino in terms of turnover.
Okay. Now, before the change of the regulations, the GWC was involved in approving junket operators and junket representatives, wasn't it?
Yes, what happened was the legislation was introduced in about 1998 or 1999 because we did recognise it as a risk, so it was the Act was amended, and then as a result of that we had to develop regulations to go through approval process for junket operators. But what we found over time is we would have to give we'd give the application to the police to help determine the probity. And the regulations are not labelled the GWC because we hadn't been regulating before to provide a interim approval to the junket operators. The problem came is that because the police couldn't get an adequate clearance about those junket operators, and I understand also Interpol stopped issuing any information which is for licensing purposes, those junket operators continue to operate under interim approval. So we were giving them status which we just could not substantiate.
So do I understand it correctly to be that they were approved without effectively the probity having been satisfied and continue to operate under an interim approval on that basis?
Well, prior to the Act, there was no probity. So we continued that on the interim basis.
So is it your understanding before the Act was amended to insert the provision dealing with junkets, that junket operations were taking place at the Perth casino?
Yes.
And they were unregulated at that time?
Yes.
What is your understanding of the reason for the introduction of the section in the Act to allow for regulation of junkets?
Because we recognised it was a risk.
And what was the risk associated with junkets specifically?
Well, the risk that the people who were involved in the junkets were criminal elements, so we were looking to see that they are suitable to be dealing with the casino.
And is that a relation to international crime, criminal elements, or domestic, or both?
It had to be. A lot of the source of the junkets and those was coming from Indonesia, so it'd be getting clearance from the local police about them coming into Australia and providing these services.
Okay, now I want to come back and to the process by which the regulations were amended. But before I do, in your statement you said that the GWC has issued a direction to Crown to cease junket operations. You
That's
recall?
correct, yes.
Now that's a direction given under the Casino Control Act.
Yes.
And if I could ask you to, have a look at the direction itself, which is GWC 0.001, 0.006, 0.0019, page 40.
While that's being brought up, did I understand your evidence, Mr. Sargent, to be that prior to the introduction of the regulations under the 1998 amendments to the Act, I think the regulations were 1999, is it your evidence that junkets at the Perth Casino were unregulated?
That's my understanding from my memory, yes.
Do you have any knowledge of whether there were directions in force at any time between 1985 and 1998?
I'd be guessing. I can't recall. There may have been, but I cannot recall.
Okay, if you can.
This is the current direction.
The direction you're familiar with, yes. Now, when was that direction issued?
Would have been at the February meeting.
2021.
Yeah.
And by what process was the direction issued? Was there a proposal that the direction be given, put to the GWC by the department?
Correct.
And was the terms of the direction framed by someone within the department?
Correct.
And was there any deliberation about whether the direction should be given?
There was discussion, but I think generally there was full support for the direction to be given.
And what was the reason for giving the direction at that time?
Well, Crown had announced the cessation of it, and given the issues to do with the money laundering, the Commission said, well, let's basically make it quite clear that henceforth they won't be able to participate in the junket market, and they would have to come back and make a submission to the Commission, I would suggest in the future, if they were to want to resume this activity. But Crown had announced their cessation anyway.
Okay, but that's essentially a voluntary thing by the Crown group.
That was them. They weren't directed to cease it.
Yes, but this now provides a direction that they are not to
They
participate
shall not.
in the conduct of junkets, which is over the page. It's defined to have the same meaning as in the Casino Control Act. And it goes on though to address specifically something defined as premium player activity and privileged player activity. And again, those activities are defined in the direction itself. And do you see those as something different to junket operations?
They are different. The junket is where someone's organising it, whereas if I had sufficient means, I could come in as a privileged player on my own right. I come in as a premium player on my own right. And
so what's the thinking behind prohibiting that kind of activity as well as the junkets?
Well, I think at this stage, even those players could still be sourcing their money from nefarious means. So I don't think the Commission discussed it in too much detail, other than the fact that it was presented in that manner. But that's you've got both the operator and the players who could give you the same outcome with respect to concerns about the criminality infiltrating the casino.
Okay, now there's a qualification, I think, to it, which it's limited to table games. Is in the definition. What do table games involve?
Traditionally, these players play baccarat, which is a table game. So rather than define it to table game, so it was just to baccarat. It was left all table games. But the machines, it's a different client base. I don't think many of them these sort of high-end players would want to play the machines anyway, so it was limited to tables.
So when you're referring to machines, you're talking about electronic gaming machines
Sorry, yes.
primarily?
Yes,
Um,
the only electronic gaming machines.
Okay, so do table games include roulette and things like that?
Yes.
Okay.
But
All right.
as I said, traditionally, these players play baccarat because it has the least house odds. I think the house odds on bank is just over 1%, so it's just about an even chance game.
So the directions intended to prevent junkets and, if you like, high-end, high net worth players from overseas, essentially utilising the Perth casino for table games.
Well, in theory, it could also be a local high-end, if that was the case. It doesn't a privileged player.
Yes, I think it's limited to non-residents though.
But there are some people that have residential status who are sourced from Asia who
Right.
can do it. But I accept that in the vast case, it is the overseas people.
All right. Now, what steps, if any, has the GWC taken, or is it taking, to monitor compliance with this direction?
At this day, I can't answer that. It was passed, as I said, in the February meeting. I think since then, more concerned with issues to do with the Bergen report and the Royal Commission to turn our minds to that one. But it's something which could be addressed in due course, but I haven't seen any agenda items, and I know the Commission itself hasn't issued any directions or requests to the department to generate an audit program for this.
All right. So at the time this direction was approved, there wasn't any. It wasn't in view at that time that the department, through its inspectors, would undertake some form of inspection and audit to ensure compliance with this direction.
There would be, but of course Crown has voluntarily said they're not doing it anyway. So the urgency of setting up a program is not there.
All right. So still staying with junkets regulation more broadly. Can I take you back to your statement at paragraph 79? I think there's a typographical error in this. I just want to check that I'm right about that. In the last sentence, you describe the process prior to amendment to the regulations. In the last sentence, you say the regulations were ultimately repealed by the Minister acting on the resolution of the GWC. I assume that you mean recommendation there?
No, well, the resolution would have been in the form of a recommendation to the Minister. It would have been resolved to recommend the Minister.
So how did that process, you were chair at the time, so how did that process work by which the GWC passed a resolution making a recommendation to the Minister? Then what was the next step?
Well, normally, as the head of the department, I would have drafted the minute to go to the Minister based on the resolution of the Commission, GWC, and that would have outlined the case as to what we were proposing.
So there would have been, you've now moved, I guess, from the role of chair of the GWC to the role of Director General of the department.
Yes.
Preparing a briefing note to the Minister. Presumably this would require Cabinet approval.
It would have been a form of a minute to start with, getting his approval to draft the amending regulation. If he said no, it would stop there. But if he said yes, we would then get permission to draft the regulation through Parliamentary Council. And in that case, the Minister could go straight to Executive Council to have that approved. The regulation change didn't require Cabinet approval.
Right, I see. So that if the Minister was satisfied that the regulations required amendment, or in this case repeal of large parts of them, he could make that recommendation to the Governor and Council.
That's right.
And then the regulations would be would be amended.
time ago. And then those regulations are subject to disallowance by the Parliament. Now, there could be instances where the Minister might say, I want to go take this to Cabinet, but I can't recall. I don't think that happened in this instance.
All right, now a little earlier, the genesis for the change to the regulations was a request from the licensee or the operator of the casino, wasn't it?
That's what I recall from this. I can't recall the detail, but it's quite a few years ago that this happened.
Yes. Commissioner, there's a bit of a debate about one of these documents. I might just not deal with it at the moment, but take the witness to a sorry, I've got the wrong document. This one actually isn't the subject, I don't think, of any objection. Perhaps my friend will let me know if it is. So I refer to GWC.002.0016.0001, page 1. This is an agenda for a meeting in February. Although the agenda says 2009, in fact it's 2010. You can take it from me. It was the following year. Just draw your attention to item 8.2.
Maybe a problem with that document.
Oh, the document's not arrived. All right. Perhaps we can put that one to one side. In any case, your recollection is that the genesis of the request to bring about a change to the regulations emanated from the operator or the licensee.
I'm pretty sure they initiated. We didn't go there and say we want to withdraw. My recollection is yes, they did request it. And it was looked at.
And the
department.
The department, a person within the department considered it.
Yes.
And made a recommendation to the GWC.
Correct, that would have been the process.
And the GWC accepted that recommendation and made the resolution we've just dealt with earlier. Now, a little earlier today, you gave some evidence in passing, I think, and I think this may also be dealt with in your statement, about, there was some evidence given regarding a change from inspectors, government inspectors being embedded, I think you said, at the casino to a more of a remote audit process. And I think you mentioned the year was 2015.
When it was yes.
Now, this may be the subject of this is the document I referred to earlier, maybe the subject of some debate. So before I take you to that, or may need to take you to that, is it your recollection that the process that led to a more remote form of inspection and audit also commenced with a request from the licensee and operator of the casino.
What, the decision in 2015?
Yeah, not the decision, but a request to change the way in which the casino was regulated internally at that time.
I don't recall that request.
All right. So if I don't want to put you on the spot, Mr. Sargent, if you can't remember. If I ask the, this document is GWC.002.0016.0148. It starts at page 1. There's a application for non-disclosure of parts of this document, so it has been redacted already. I don't want to deal with that aspect of it at this stage. The redaction parts I don't need to take the witness to. I just want to take the witness to the letter that starts at page 6 of the document, which is a letter of the 29th of January addressed to Mr. Sargent. And if I could ask you, Mr. Sargent, I know there are parts of this that have been also redacted, to take an opportunity to read it. Came separately. It's April 2015, but this particular item came separately. Agenda item 6.5.
I read that section in A, B and C.
Yes.
I read E.
Incidentally, is the handwriting on this document yours?
No.
Right.
I haven't. I didn't initial that at all, so somehow it might have gone straight through to the section. I don't think I've initialed it. I didn't see my initials on it.
Do you recall whether do you have a recollection now whether you remember receiving this
I can
document?
recall the issue of this is table supervisions, which is a difference to the idea of us reducing or taking inspectors out to roster them out. This is the table supervision issue, which is built around the casino's CCTV coverage.
All right. So this is you're saying it's unconnected to the.
Unconnected, yes.
All right. Then.
From my perspective here, because I was aware that that's the pit bosses and the configuration of how many tables that they can supervise.
Okay. So there was a. This may be.
Mr. Sargent, do you recognise the handwriting?
No, I don't, as a matter of fact, no.
Right, could I ask that the Mr. Sargent be shown GWC.0002.0016.0155 at page 1. This is the commencement of the document. I think this document has already been put into evidence, or has been dealt with yesterday. Is it the whole of page 1? Is it? Is that the reference 1? Looks like it's all been redacted. It's going to make it a bit difficult. Perhaps we could take you through to page 17 and agenda item 6.2.
So this was August 20. It would have.
Yes.
Would this have been the recommendation which led to the decision to adopt the President's to 20.5 hours a day?
Yes.
Yeah.
Do you have a recollection of
And I think that the decision of the Commission was to endorse the recommendation.
Yes, I want to take you to attachment 1 to that agenda paper, and it's a document. Starts with heading Casino Compliance Strategy. Have you got the?
Attachment 1?
I think you can take your time and read the whole document if you wish. I've just got a couple of questions about it.
Okay, I've done that. Scroll it down. Okay, page 20, next one. ATF there stands for Approved Testing Facility.
Yeah, yes. Is it, which page are you reading from, Mr. Sargent?
I don't know, I've got a page reference here,
Oh,
but
yes.
it's under Casino Revenue and Tax. They use ATF quite a bit, but that's what it means.
It comes up, that's right.
Yeah. Yeah, what are our priorities? I can scroll to the next section, thanks. Okay, continue on. Next page, thanks. Any more? That's it, is it? Yeah.
Have you got to the, there's an organisational chart at the very end of the document, or sorry, it's a high-level process document, the flow chart of the process.
Compliance planning and action process.
It's on page 25. Yeah, that's it. You've been through that as well.
Okay.
Now, is it your understanding that this attachment to the recommendation, which is that of Mr. Connolly, that that document entitled Casino Compliance Strategy was accepted by the GWC at that meeting?
It was, and I accept it as an aspirational document.
What do you mean by that?
Well, in a sense as to how we could go forward. It wasn't saying, it wasn't, I don't recall it, and I don't know how the minutes reflected it, but I can't recall it being saying, well, you must do that to get that.
Okay, but does it, to your, has there been any change to your knowledge to this particular strategy since it was
No.
And does it reflect your view of what the GWC strategy is today?
Yes, but I don't think we've achieved as much of it, but the philosophy would have been there. Mm.
Okay, so in other words, what are described as the objectives of the strategy remain the objectives of the GWC's objectives
But
today?
I'm not sure whether that's been brought forward to some of the new members of the GWC, which has been quite a generational change.
Well, to your knowledge, has there been any suggestion at meetings of the GWC that there is a need to review the casino compliance strategy of the GWC?
Well, the Commission's been talking about the need to have a planning session for some time, and I think they're organising one, but this sort of document would be one. Given that Mr. Connolly's not there, I don't know whether the people preparing it would have actually identified that as a document to be a starting point.
Can I just I draw your attention to the heading, how the department will achieve these objectives. So it's not phrased how the GWC will achieve these objectives.
Yeah.
It's referring directly to the department.
Yeah.
And it says the department will take a proactive and risk-based approach in targeting, continuing and operational compliance activity, etc. There's a reference there specifically to a risk-based approach to how the department would approach the compliance strategy. In your view, does that represent a shift in the GWC's approach to compliance?
I think quite often you would have found that the interchange between department and GWC as to a compliance strategy, but the move to having the inspectors not being there on being rostered to go on there is part of the strategy towards a more of a risk-based. Anyway, so that it was being embodied in what was happening in the programs that were being undertaken.
So you're saying there was a move, GWC was moved, well, I guess on recommendation of department, was moving to a risk-based sense of management of
particularly on the floor of the casino. You know, that is more on the casino footprint. I don't think it was embracing what we were talking about earlier about the bigger picture of the risks that was identified in the terms of reference for the Royal Commission. It was more about the.
You were not managing those other risks.
I know,
you were
but
leaving those to other departments.
Yeah, that's what I'm saying. That's what the risk was. It was about the floor of the casino.
But would you accept that it reflected a change in approach from, let's say, at the time it was embedding
Yes.
inspectors, they're really counting money, as you said earlier, and ensuring that the things that were being inspected were actually being done on a day-to-day basis.
The philosophy it started some time ago. It hadn't been documented as such.
And when do you say that philosophy began?
The decision to go from the 24/7 surveillance, then back in 2002, there would have been a greater acceptance of the need to be a more risk-based phase, because you couldn't have someone there at certain times of the day, so you were addressing it. But this would reflect more of the status as at the 2015 point.
Was there if you like, a formal bright line in the sand moment with the GWC where there was a recommendation that we move away from a more prescriptive approach to regulation to a risk-based approach?
I can't recall that ever being the case, no.
Would you accept that it was a more incremental approach?
Yes, I would.
So would it be fair to say there wasn't any, if you like, recommendation by the department specifically to change the approach?
Correct. This was probably the recommendation would have been quite specific about going from 24/7 to having the inspectors there at certain times. Then the next one was the decision to put them more on a roster. They're the two monumental decisions of the Commission.
Again, you can disagree. Would it be fair to say?
Sorry, the GWC. Yeah.
Would it be fair to say that the move to a more risk-based approach was something that really happened without any consideration being given to the change from prescriptive approach to risk-based?
I don't quite understand where you're coming from. Can you rephrase it? Sorry.
Well, a conscious decision to change an approach to regulation would be, we have a prescriptive approach one day and we decide that we're going to move to a risk-based approach the next. There would be a conscious decision made to change the methodology of regulation. Here, based on what you've said, it would appear to have been a more iterative and incremental approach without someone deciding they wanted to do it directly.
I can't recall what happened in 2001, 2002 when the change was made, but that was a recognition that we had to go to a more risk-based. So whether it was a decision which meant that as from the next day it was totally risk-based, I can't recall, but obviously it was incremental to get to a stage.
What was driving the change to a risk-based approach?
Well, we think it was more cost-effective, and the question you had to ask is that were we getting what value added was being achieved by having inspectors there 24/7.
So there was, and it was driven partly by fiscal efficiency and partly by utility.
Yeah. And a philosophy, I think, that you could achieve the objectives without having to have people there 24/7.
When you say philosophy, where was the philosophy emanating from?
Would have been from the department.
From within the department
Yes.
itself? And who in particular would have been the source of that
But
philosophy?
I can't recall, but it would have been we had I think we still had him on staff, an accountant who may not have an accountant, but I know he was driving quite a bit about the risk-based side of the activities, and moving more towards an audit approach rather than just the surveillance and approach.
In a risk-based approach, would you accept that it requires the party regulated also to take some responsibility for ensuring compliance with the regulations?
That's part of the philosophy, and there's normally internal controls, but you also ask the question is, do you need to do something when they've got their own controls in place? So all you do is check to see that those controls are being complied with. It does, I agree.
And it requires you to effectively trust them to do the right thing, as it were.
Yeah, yes.
And rather than standing there watching over their shoulder to be satisfied they're doing the right thing, you need to take other steps, audit and inspection.
It meant that, well, casinos are a classic case of internal controls, so it's a matter of you utilise those internal controls, because the management has got as much of an interest as the regulator to ensure that things are complied with.
Why do you say that?
Well,
The management has the same incentive.
have an objective of compliance. I believe that the chair of whether it was Burswood or whether it's chair of Crown, because they're absent from the organisation, would have an incentive just as much as I, as the chair of the commission, to make sure that there's compliance.
And do the GWC undertake any process to investigate the internal compliance system of the licensee in the Crown Resort?
I can't recall that far back what would have happened, but as part of the decisions, I can recall there was some reference back to the internal controls and their internal audits, but I can't recall that precise nature of the decision and what was considered from the point of view of the operator.
All right, in your time as chair, do you have any recollection of utilising the power to make a recommendation to the minister under section 21A of the Casino Control Act? You know the section I'm referring to, the one that requires investigation?
We didn't recommend to the minister do an investigation, but I can't recall, but we did recommend that we take some action against the licensee on 2 occasions. But we had done the work within the department, and the commission had recommended to the minister that they take action, and had given them notice that there was going to be a penalty imposed. I think it was twice, in my recollection of, twice over the time that I was chair.
And did the information come to you as a consequence of the inspector audit and inspection process, or by some other means?
I can't recall. One was a juvenile that had been let into the casino and had lost quite substantial amounts of money. The other one, I can't recall the detail of it, and how that came to our knowledge, I'm not sure. I just can't recall, but I remember there was one about the juvenile gambling in the high-end facility. It would have been, I think that one was around about the year 2000.
Commissioners, that concludes the questions I have for this witness at this point in time.
But you will be coming back to other matters in due course?
It is our intention to come back to other matters in due course, and perhaps touch on some of those things in a bit more detail at an appropriate time. But I think now we'll provide an opportunity to the other council to ask any questions they may wish to ask.
Yes, and I'm pleased to note that it's gone past 3:15 without incident. Do you have any questions?
No, thank you. Not at this stage, Mr.
Seawood?
I just had 1 or 2 short questions on some of the issues on the relationship with the department. Sargent, you were asked a series of questions about the support provided by the department to the GWC. And I think in the course of those answers you spoke of the support consisting of two aspects. Firstly, the inspectors conducting their audits and inspections, and then what was, I think, summarised at one point as administrative tasks. I just wanted to touch on those administrative tasks. Is it fair to say that there are quite a lot of tasks that would fall under that category? And by that I mean there's the clerical tasks of physically preparing, collating and gathering board papers, for example. But in addition to that, officers within the department will be preparing the underlying papers themselves. Is that correct?
Yes.
And the preparation of the papers could vary, but in some cases it would be involving a task of researching different policy or factual options. Would that be right? Compiling a paper that collates all the information that's been gathered and all the research that's been gathered. That's a yes, sorry,
Yes,
just for the transcript.
sorry,
Thank
yes,
you.
I apologise. Yeah.
It's the end of the day. And that work can be quite complex and quite detailed work that goes into those papers.
Yes.
And the purpose of doing that work is to put forward options for the GWC to then consider for themselves.
The intention is that the members are fully informed, and if they weren't, they need clarification, then there was no hassle or no problem in deferring an item.
Yes, that would be my next point. So it was a two-way street then during the GWC meetings. Questions could be asked by the commission members to the departmental officers that were present.
Yes.
And if further information was needed, it would go away, and the department officers would go away and gather that information.
Yes.
And to the extent, as part of doing that work and providing that support to the commission, there was a feeling that external consultants were needed. That was an option that was open for the GWC to discuss with the department about adopting.
They'd never ever be denied. If they need something, that will always be considered.
Now, you were asked some questions about the regulation of junkets, and you're asked some questions about when the casino control regulations came in 1999 that had those junket approval processes in place. You said to the best of your recollection, there wasn't anything beforehand. Was that your evidence?
That is, but as the Commissioner, I think, referred to whether there was in the directions, I can't recall if there was anything in the directions.
I was going to ask whether it may have been possible that prior to those regulations coming in, there were directions instead that dealt with
There could be.
regulation
Yes,
of
there could have
junkets.
been. It was quite possible. I just can't recall.
It is. Thank you. You were then asked some questions about the directions that the GWC endorsed and then were put in place earlier this year. And you were asked some questions about what steps the GWC put in place or the department put in place to ensure that they were complied with. It's the case, isn't it, that no junkets are currently taking place?
That's correct.
And that's for two reasons, isn't it? Firstly, because Crown has voluntarily agreed not to conduct junkets,
Yes,
but also the international borders are not open, are they?
correct.
So at this point in time, there is no need to put in place steps to enforce the directions because they physically can't be contravened.
That's correct.
And if and when, at the very least, the borders open, that's when theoretically junkets become possible again. That's correct?
That's correct. And I don't see it as a difficult exercise to audit that. It won't be a difficult thing to organise.
That will be part of the ordinary audit tasks that the current inspectors undertake. It can easily be added to the tasks that they do.
I would see it as similar to what's happening when the casinos had to close for COVID. There was a reopening process that had to be done. Those facilities will require quite an extensive procedure, getting all the tables back and all the chips under control as well. So, as I said, it's something which wouldn't be very straightforward to audit. It won't be very complicated.
Thank you. Now, you were also just recently shown document GWC .0002, .0016, .0155, which was the August 2015 agenda papers, if that could be brought up, and page 22. I know you're asked some questions about this page. This page, doesn't it set out the casino compliance strategy? It does that in the first paragraph, sets out what the strategy will be and its objectives, is in the next heading. And then there are two parts. The first part deals with how the Commission will achieve those objectives. That's correct?
Yes.
So it's not just limited to the department. It sets out firstly what the Commission will do. That paragraph notes that the Commission will utilise officers from the department to conduct various compliance-related activities. Is that a fair summary?
Yes.
Then the remainder of the document goes on to describe how the department will achieve those objectives. That's correct?
Yes, and as I indicated there, sometimes the word department or the word commission, GWC, can be interchanged because the objectives are effectively the same.
So this sets out, doesn't it, that this is what the department will do, but
yes.
that is to inform the Commission as to what they are doing, so the Commission can see how the strategy objectives are being met.
That was the aspirational aspect of the document.
I have no further questions, thank you.
Yeah. Mr. Malone, anything, Mr. Malone?
No questions from me.
So I just have a few questions, Mr. Sargent. Can I ask about the risk-based strategy? Would you agree that in order to employ a risk-based strategy, the first thing you've got to do is do a risk assessment?
Yes.
So what risk assessments did GWC instruct were to be carried out after that compliance strategy was employed?
Given what I've just said to you, I don't think that was undertaken. I can't recall that being undertaken. The only thing I can say in defence of that is when it comes to looking at particularly the activities on the gaming floor, the risks over time hadn't changed dramatically because I've indicated in the evidence it's a very mature product. The playing of many games are the same because they were 85 to 2021 and 2015. So I don't think it was a major issue from that point of view. But had we, as council has indicated, talking about changing our approach towards those risks, then I think we'd have to do quite a detailed risk assessment to take that on if we'd proceeded down that path.
Because you spoke in relation to junkets that you had, for a long period of time, appreciated that there were risks associated with junkets. So if you were going to a risk-based strategy, it would be relevant to have a look at junkets again, wouldn't it, to see whether there were risks there that you could address.
But looking at what you're saying now, I agree, but at the time, when I say we, there'd be more the department than probably the commission had been, Gaming and Wagering Commission had been asked. You're looking at where we're going to go back into that particular area to identify what we could do to mitigate or change what we experienced back in 2009, and that was not addressed, no.
You said in your evidence that money laundering with respect to the Riverbank account was not so easy for you to detect, and I'm not quite sure whether you're referring to GWC or the department there, or you may have said, but I haven't made a note of that. Do you recall who you were referring to there?
I was probably in the evidence referring to myself in the sense that I wasn't even aware that the accounts were open and operating until I think it was about August or September 2019 that they had the Riverbank accounts operating. So
I wanted to ask you about that because having read the Casino Control Act, there's provisions in there which says that basically the accounts operated by the casino have to be available for inspection by the inspectors. Are you saying that the Riverbank account was never made available for inspection, or did the inspectors never ask to inspect the accounts? What are you saying there?
I've only become aware of it, as I said, since 2019, and even then it was in the context of Crown responding to the 60 Minutes investigation, and it probably didn't register to me at that point. But later on, when I have asked what came in, first of all, I was trying to say, did they actually advise us formally that when they opened the accounts? The information I've got so far is I've gone back to about 2012, and there's no record of any advice from Crown that the accounts have been opened to the Commission or to the department. I haven't been able to see what was actually provided. I understand, but I haven't seen it, that the Crown was attaching statements to their revenue reconciliations. I don't know what the inspectors were looking at or whether they actually asked questions when it came in. So I've got no detail as to what was going on with respect to the Riverbank accounts. Now, I've only come aware of it since I've been a commissioner, and something which had it happened when I was Director General, then I'd known about it. We would have had to find out what was going on. So I can't answer the question about what was supplied. I don't know.
In respect to your evidence about relying upon other agencies, just wanted to ask you the extent to which you spoke to those other agencies, either as Director General or as Chair of the GWC, or directed the department, being a bit convoluted because I want to only have to ask one question at the end of the day. But basically what I'm asking you is that in assessing that AUSTRAC and Border Force and WAPOL were carrying out functions which would detect money laundering at the casino, what inquiries were made of those entities to actually get formal advice that that was what they were doing?
I didn't make inquiries formally. I had some informal associated with the WA Police at various levels, but nothing formal. I didn't do that. I accepted that nothing had come to us from those bodies, and particularly would it be WA Police or AUSTRAC. I didn't expect it would come from other bodies, but particularly WA Police, there were some issues. Yes, I did rely on them to raise issues with us rather than the other way around.
And in respect of the licensee, did the licensee say anything in its submission to the GWC about removing junket authorisations and regulations, which led you to believe that those other authorities were covering the field, so to speak?
Well, I can recall that when we've had discussions or any issues raised with this area, they were looking to particular border control over visa entry, and the other was the AUSTRAC requirements with respect to money laundering. But they didn't mention, I can't recall, but I can't mention anything about AFP and those sort of bodies. But it was normally the Border Force and AUSTRAC was the reference, from my memory.
And so do I understand from your evidence that as you didn't make any formal inquiries with these entities, that neither did you seek, either on behalf of the department or GWC, to enter into memorandums of understanding with them over these?
Correct.
Can I move to another topic now, and that's the question of the recouping of the value of services provided to the GWC by the department. and I think your evidence was that you think that was done, the value of those services was determined by finance people within the department. Is that right?
And there would have been some reference back to the various heads of areas about their requirements, but essentially the finance people ran the process.
Is your understanding that the department sought to recoup the value of all the services it provided to the GWC from the GWC?
Yes. The department's budget was premised on that principle.
You mentioned, going now to another topic of, you acknowledged that the GWC has a role to play in respect of suitability of close associates of the licensee. Do you recall that evidence?
Yes.
And you said that the GWC could make inquiries in relation to those issues if information came to it which raised issues about suitability. Is that the import of your evidence?
Yes, if they raised it with us, we could have that. If the Commission decided to do something, it wouldn't be done by the department in its own right, because it does require the Commission to make recommendations to the Minister.
Sorry, say that again. I just missed.
Well, if you look at the requirement to do things, the Minister would get involved in it. So I'm saying it's not something that would be done by the department. The Commission would be involved in any decision to investigate something if we received information. I don't think the department would just go off and do it on its own volition.
So I was going to just raise the example when there was information about Melco becoming perhaps a close associate of Crown or the licensee. Do you recall whether the Commission, the GWC, ever discussed that? And
we did, because the Melco was. This is the one where they were going to take more than 10%, because we would have discussed it from the point of view of having to approve them under the Casino Birds Island Agreement Act, where they had to get a probate approval notice. But that eventually did not transpire to the full extent, if I remember correctly, so that we didn't have to go on and do an investigation. We were looking to do it in conjunction, particularly with Victoria, if it had gone through.
So how far did you get in that process? Was it an agenda item at a meeting? Or?
Well, I think it was, but I can't recall. But it was something we were conscious of. The fact is, if they were to take more than 10%, then they'd have to get a probate approval notice from WA from that one. But that was very much on our agenda. And given that it was required under the Casino Birds Island Agreement Act, we didn't necessarily rely on the close associates provisions under the Act, because we were looking at the 10% margin. But if we thought we had issues at less than 10%, you could use the close associates provisions. But it was more looking at it from the point of view of the probate approval notice, which talked about more than 10%. That's how we were proceeding on that one.
Just then going to your witness statement, and I've just made a few notes on that about things that I wanted clarified, so bear with me. The first one was in respect of paragraph 20, but it's also referred to you've also referred to this point in your evidence. And it's referring again to other entities being relied on by GWC in respect of criminal matters. Can I just ask you, under the Casino Control Act, it's actually the inspectors, the government inspectors who are on the ground in the casino footprint as you've described it. having regard to that, aren't they in the best position to see what's happening at the casino, to inspect the books, in a better position, say, than Wapol, who doesn't have those powers?
Well, I would suspect if it would work the way if Wapol had suspicions about an entity of some form which could relate it back to the casino, we would do the work, which is what you're referring to. We could use our powers and the inspectors' skills to look at the books within the Crown, Perth.
So in that respect, would it be helpful then to have an MOU with the police, which set out the roles that you each might take?
Well, I can't deny the advantage, but it wasn't something which we or I pursued in that time frame.
Looking at paragraph 22 of your statement. There's a reference there to a delegation dated the 28th of April 2020. This is perhaps more something the parties might be able to tell me more than you, but I just didn't recall having seen that delegation. Mr. Evans, is that a written document?
It is a written document. I have a feeling it might have been produced in one of our bundles, and I think a copy might also be annexed to either Mr. Ord's or Mr. Connolly's statement from memory, or referenced in there.
If you could,
They're readily available.
That would be helpful, thank you. Can I just ask you, Mr. Sargent, what is your understanding of why that delegation was made?
If I recall correctly, it was to do with COVID issues. Availability to do things quickly, and the classic one is we had many people who had taken out permits to conduct lotteries, raffles, and they couldn't sell them. So rather than get a commission meeting to decide or get road resolutions, it was easier to let them go ahead and just let them cancel them or vary dates and things along those lines. That was one of the principal things about that. Anything else could come up that could be handled very, very quickly if need be, but that was very much COVID driven.
Thank you. Moving on then to paragraph 30 of your statement. You're referring there to a trip you made to Macau.
Yes.
And it says at the end of that paragraph, to see, so that I, in my Director General role, could better understand Crown's competition in Asia. Could you just elaborate on that, why it was important for you to better understand Crown's competition in Asia?
Well, Crown's perspective was that the particular Chinese market was going to be very much part of their strategy, and they were looking beyond the completion of the hotel now, and when the matters were coming for particularly the minister and the government rather than as the Gaming and Wagering Commission, which required action under the Casino Birds Island Agreement Act to implement. They just thought that people like I in particular and didn't appreciate what their competition was up there. I hadn't been there for many years, so they were keen for me to travel to Asia and to look at the facilities. That's what they were proposing, and as I've indicated there, I didn't think I had the budget item there, but.
And did you have any view at that time in 2013 about the Chinese government's view about Chinese citizens coming to Australia to gamble?
No, I didn't, no.
But your understanding was that you were going there in order, because that was the business strategy of Crown.
I understood that Crown were looking to have the three sites, the Sydney, Melbourne and Perth, as a suite of sites to attract the gamblers from mainland China, and it was very much a strong part of their strategy. And that's with their commitment to the Crown Towers Hotel was a very important part of that. But they were looking beyond once the hotel was completed as to what they might need to do. And of course, as we know, what they planned to do, what eventuated, changed once the Chinese situation deteriorated.
Thank you, Mr. Sargent.
Mr. Sargent, I have a few questions to ask of you. Could the paragraph 12 of the statement be brought up? I want to ask you some questions about, I want to get a feel for the way in which the board of the Gaming and Wagering Commission operates. And someone once wrote in criticism of a board of a company that there was a lack of robust and sceptical questioning. And that can, of course, be done respectfully. But in terms of the way this, and I'm asking you about your period when you were chair of the commission, the Gaming and Wagering Commission, and as a member of the Gaming and Wagering Commission, can you give me an impression of the way the Commission interacted in terms of their approach to the resolution of issues that came before them?
I wouldn't say that the commission members questioned the departments extensively on the matters that was particularly when it came down to technical aspects of the games. If you look at the commission composition now, I would say there isn't much more questioning. The group that the Minister Papalia has appointed, there's questions that much I think questioning things much more in depth than previous commissions. That's my perception. The reliance on the department and me signing off on it, in a sense, it was them just checking to see that we were being fair and what was in the community interests.
All right, and if paragraph 17 of the statement could be brought up. This is what was given to you.
Yes.
And I'm going to make an assumption, and I'll ask you to make the assumption that this is the sort of material that was presented to other new members of the Commission as they came on board. I'm going to ask you to make that assumption.
I presume so, yes.
Now, have you had any experience in, I think, paragraph 8, no need to bring this up. In paragraph 7, you mentioned a number of other statutory boards on which you've been a member and sometimes ex officio chair. Leaving them to one side, have you ever had any experience of being, say, on a not-for-profit board in recent times?
No.
Well, again, I'm going to ask you to assume that what I'm going to say here, that with almost all not-for-profit boards of any size and complexity, there is a rigorous process of induction and formation about the underlying philosophy which drives the organisation. You can call it culture, you can call it all sorts of things, but it's really about the philosophy. And in the case of the Gaming and Wagering Commission, I would have thought that the regulatory philosophy that underpins, that arises from the legislation and the statutory remit is an important factor. Now, there's nothing there to suggest, apart from the black letter law, there's nothing there to suggest that there was any form of induction or formation at that level of regulatory philosophy. Is that a fair statement?
That is fair call, fair.
And just going to paragraph 58, and you gave some evidence about this morning, and you said that there have been two occasions on which you have made suggestions to the Minister of People who should go on to the Commission, and on both of those occasions were accepted. But it looks to me as if, generally speaking, that's not the case. And you, as the chair of the Commission, and the other members of the Commission were simply told who was going to be their fellow members, their new members. Is that a fair statement?
Yes.
Just sitting back now, does that strike you as at all odd?
It does, but working closely with government over the years, I probably accepted it as a norm in this sort of area.
Is it your experience that over recent times, the approach of government generally to statutory boards of this nature has been changing, and perhaps coming closer to a more contemporary standards as they're used in the commercial world and in the not-for-profit world?
I wasn't aware of that, but in the case of the Gaming and Wagering Commission, it was a matter of that these people had been selected to prepare a draft of the cabinet for the appointment. No, I wasn't. Because I hadn't had an involvement in the commercial boards, nor had I had an involvement in the not-for-profit.
All right. Can I come to some other matters? Can I turn to the question of conflicts generally? You've mentioned that there was a discussion, you can't remember the exact details, there was a discussion with Mr. Connolly about his association with Mr. Murray, and you also recall that you were aware that there was a work relationship with Mr. Hume, which Mr. Hume then went on to the work for the casino. Now, those two things aside, and leaving Mr. Connolly totally to one side, were there, in your period as the chair of the GWC, were you ever advised of any other possible conflicts of interest between an officer of the department and the casino?
It never arose, but the chief casino officer, which I referred to this morning, who was the inaugural chief casino officer, he took some secondment and went to work, I think, the Workers' Compensation Board. And when that happened, the casino approached him to join them. Now, there was nothing in the legislation to stop him, and he did join the staff of Crown. He would have known many people within the agency, but I have utmost respect for Mr. Regan, that I know he wouldn't have gone beyond those bounds. But no, not once did I have any other issue raised. I was aware that one of the inspectors was married to a croupier. That was one person. But I think it was married before I arrived anyway. Yeah.
And the next question I'm going to ask you, I only want a quantitative answer. I don't want you to name names or give circumstances, but in your broader remit as the director of the department, as it's from time to time, not only the casino, was the issue of conflicts a significant one, or did it hardly ever arise?
Hardly ever arose.
Can I come to this question of the footprint of the casino? This is paraphrasing, but I think what you said in evidence was that if something were to occur within the footprint of the casino, I'm talking here about criminal activity of some description, if something were to occur within the footprint of the casino, then yes, that would be within the GWC's remit. But if it's outside the footprint, then it becomes more difficult for the reasons which you've explained. Is that a fair statement?
That's fair summarisation.
I want to just ask you a bit more about the concept of the footprint of the casino. And let me put it to you this way. Criminal activity that might arise, for example, by the use of a bank account, it's to do with the casino, but the bank account is held in the CBD or maybe in Sydney. Is that within in your understanding, the way you've used that term, the footprint of the casino, is that within the footprint of the casino?
No. What I would suggest, if there was something to, again, if it had come from the police or some other source to identify some issue, then we could use our powers to access some information. But again, I understand that we've got limited where we can go to because our powers are basically West Australian based. And then there's always the issue of whether it's a state responsibility or a Commonwealth responsibility to access information. But I wouldn't see that as the footprint in the CBD.
But is there not, if it's to do with records, for example, is it not a statutory obligation for the records to be held within what you're referring to as the casino footprint?
From Crown's point of view, if they would be, but are you talking, for instance, are you talking about the accounts of some of their clients, or are you talking about Crown's?
I'm talking about Crown's account.
Definitely. I think we've got the ANZ Bank. I'd have no qualms about accessing the accounts if we needed it. I was thinking more about the accessing the accounts of people who are putting money into the bank account.
And can I ask, this is going to be a very broad question, but again, I'm going to paraphrase, and please tell me if I haven't got this right. But when you were in exchanges with Mr. Futrell about the regulatory function that involves community interest or public interest, and I think you agreed that those terms in your mind were interchangeable.
Yes.
There were really three things. One, the fairness aspect, so that the user of the facility could be confident that that game was being played according to the rules that had been set and agreed. That's the fairness aspect. The second one is harm minimisation. And the third was the questions of suitability. The broad question is this. In terms of the regulatory approach to ensuring that the gaming operations of the casino are free of criminal intervention, that there may be a distinction between being a law enforcement agency and actually detecting and prosecuting crime, which may well be, as you've said, the province of other authorities or agencies, and for which other agencies have more resources and more expertise. That on the one hand. But the insurance, the assurance that whatever it is that is said to you about processes, I'm talking here about processes, for the minimisation of the effects of criminal infiltration is tested. In other words, there's an audit process for the processes rather than the actual detection and the investigation, detection and prosecution of the illegal activity, if that's what's found. And I should say there's no insinuation in that question. It's a question here of process.
So what,
So the distinction that I'm drawing is between a role for the Gaming and Wagering Commission as a frontline detector of, investigator of and prosecutor of criminal activity on the one hand, and the regulatory role of a Gaming and Wagering Commission as an assurance process, an audit process for the processes that are said to be in place.
well, I would agree that it's the latter one, it's the processes that we would be undertaking. I'm very confident we had the fairness aspect under control. In looking at some of the other aspects of the remit of what you just said, we weren't as much concentrating on the process side beyond, that is the processes of what Crown was going on within the gaming footprint of the casino.
All right, thank you. Mr. Evans,
I think not at this time, thank you, Commissioners.
anything arising, Mr. Futrell?
No. That's sufficient.
All right. Thank you. Mr. Sergeant, I'm not able to discharge you. We will need you again. We'll give you as much notice as we can. But so far as this aspect of your evidence is concerned, it's been very, very, very suitable for our purposes. Thank you very much. Mr. Dharmananda, the question of the non-publication order, what we'd like to do is hold it over for a little longer because there are some issues that we want to raise with you. But what might be helpful is if your instructing solicitors could prepare a minute of order.
Yes.
That would, and then we'll be able to tomorrow. But in the meantime, the current situation is maintained that those documents are available only to the parties who've been given leave to appear, and they are not to be published to anyone else in any respect, anyway.
Thank you, Commissioners. We'll attend to a draft of that in the proposed orders.
All right, and Mr. Evans?
Commissioner, you indicated, you sort of asked me whether I could locate an order for the purposes of Section 29A, which had been made. I have located one. It's in the Government Gazette for 7 September 2004, number 159 at page 38, which follows on from some amendments to the casino control regulations. It appears to set $1 million contract limit. There are some exclusions of the type of contracts to which it applies. That's the only one I've been able to locate at this time.
Thank you very much. We'll adjourn and resume at 10 a.m. tomorrow. Thank you.